The jury gave her $25 million. That's what was reported in the news story. $25 million. The question I have for you is, how much of that money do you think she actually walks away with? Would you like to know the answer? Come join me for a walk as I head to the train, and I gotta go return something to UPS, a return to Amazon, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This was a medical malpractice case. The news story reported that they awarded $25 million, as if this was some jackpot, as if this was some reward for what occurred to her. Do you think this woman woke up in the morning saying, hey, you know what, let me suffer all these horrible injuries, let me be incapacitated, let me be disabled for life, so that I could get an award, as if you're going to the carnival, and now you get an award of $25 million. No, this is not an award. You know what the money is? The money is compensation for all the harms, losses, and damages that this person suffered as a result of someone's carelessness. That's what the money is for. But the news media doesn't report it that way. Instead, they think it's an award. Okay, putting that aside for a moment. Now, the jury decided that yes, the doctor was careless. And yes, as a result of the doctor's carelessness, she suffered injury. And yes, as a result of those injuries, she now suffers permanent, disabling injuries that will affect her for the rest of her life. The jury gave her significant amounts of money for pain and suffering from the time of the incident up until the time of trial. That's known as past pain and suffering. Then the jury also decided that she was entitled to receive money for her pain and her suffering into the foreseeable future for the remainder of her life, for a certain number of years. In addition, the jury also determined that she was entitled to receive money to compensate her for all of the lost income that she experienced from the time of the malpractice up until the time of trial, which was a few years, and then into the foreseeable future. This was a young woman. So now, adding all of those things up, it now came to approximately $25 million. Now, here's something you might not know. Before the verdict, there were settlement discussions that went on between both sides. Settlement discussions which were substantially less than the $25 million that the jury ultimately decided she should be receiving. Now, at the end of the trial, what do you think happened the moment the jury came back with their verdict? The very first thing that happened is the defense attorney jumped up out of his seat, literally, and yelled out, "Judge, I asked you to throw this verdict out," as being against the weight of the evidence. The evidence is inconsistent with a verdict showing that this person, this injured patient, this injured plaintiff, should be receiving any money at all. This patient should have received nothing, according to the defense. So what the defense lawyer has done now is they have asked the judge to throw the verdict out because they say, in legal terms, it is judgment non obstante verdicto. Basically says the evidence is not consistent with the jury's verdict. And because of that, we ask you, the trial judge, to throw this verdict out. So the judge has a decision. Should he go ahead and throw the verdict out, or should he leave it alone? Now, a lot goes into that answer. The judge is not going to make a snap decision, usually. Instead, the judge will tell the attorneys to put all of their ideas, to put all of their thoughts and conclusions, and importantly, to put a legal brief together to support their position and submit it to him after the verdict is done. Now, that's known as post-trial motions. A motion is simply a request for the court to do something after the jury has rendered its verdict. So just because the jury goes ahead and gives a substantial, according to the news reports, award, a substantial verdict in favor of the injured plaintiff, now, the very first thing that's going to happen is the defense will ask the court to throw the verdict out. That's number one. If the court does agree that the verdict is inconsistent, you know what's going to happen? The court is going to throw the verdict out. In which case, the injured patient is now going to have to appeal that decision. Okay, what happens though if the judge decides, no, I'm going to leave the jury verdict as it is, and now, if anybody wants to appeal that decision, they can go right ahead and do that. So if the judge decides to leave the verdict alone, Now what he's saying, okay, I don't believe that the jury verdict should be disturbed. If anybody has a problem with that, meaning the defense, now they can go ahead and take it up with the appeals court. So now, do you think that the defense is going to rest on that decision? They've just been hit with a verdict for $25 million. They were trying to settle this case for much, much less, a fraction of that. The plaintiff would not accept it, feeling that the injuries were worth substantially more. So, do you think they have anything to lose by going up on appeal? The answer is not really. They will still have to pay the attorney's fees. They will still have to pay any costs associated with an appeal. But that's nothing compared to what they would have to pay if they were forced and compelled to pay this $25 million verdict. So what do you think they're going to do? They're going to appeal. Now, an appeal can take anywhere from 1 to 2 years to reach a conclusion. And in case you don't know, going up on appeal has many unknowns. It's unknown what the appellate court is going to do. And the appellate court has many different decisions and options on what to do. For example, the appellate court could look at the verdict and say, you know what? We think that the verdict is insufficient, and we recommend increasing that amount. Could you imagine that? They're appealing a $25 million verdict, saying it's too high, and the appellate court could come back and say, no, based upon the injuries, based upon the expert testimony, based upon everything that happened at trial, we think that this patient, this injured victim, should receive more money. That is a possibility. That's called an additur, A-D-D-I-T-U-R. That's another fancy legal term, meaning that the amount that this person is to receive should be increased. On the other hand, they could come to the conclusion, the Appellate Division, could come to the conclusion that this injured patient should receive less money. That's known as a remittitor. Again, that's a fancy term that basically says the amount should be reduced to some number that the Appellate Division feels is appropriate. On the other hand, the court could say, you know what? There were errors of law made during the trial. We think that the verdict should be thrown out, and now all the parties should go back to trial and try the case all over again. In which case, you have to start all over again. The Appellate Division could also turn around and say, you know what? We think that the first part of the trial was fine. There was no issue whatsoever, meaning that the jury verdict showing that the doctor was responsible, that he was liable, and that his carelessness caused this patient injury was fine. However, we do have a problem with the amount that the jury gave this patient, and so we are directing that you try this case all over on damages. So now you would have to have a new trial to determine how much you are to receive for the pain and suffering, for the past and the future, as well as the lost economic loss, which is the lost income from the past and into the future. So there are many different options that the Appellate Division could reach when reaching their decision. So just because an injured patient receives a verdict of $25 million, that does not mean she's going to walk away with that. Nobody's writing her a check as she's walking out the courthouse door. It's not happening. The defense is going to do everything possible to get that verdict thrown out. And if they cannot get the verdict thrown out, then guess what? They're going to do everything possible to appeal that verdict and try and either get it thrown out or send it down, meaning reduce that verdict, or try the case all over again and hope that they get a better result this time. So why do I share this great information with you? I share it with you just to give you a little insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I realize you're likely watching this video because you wanted to see the scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.